been 16 years since a teenage boy was shot in his home by Cleveland police. Two officers were trying to question 15-year-old Brandon McCloud about a pizza shop robbery before they opened fire.
Bullets start flying, and I ducked by my car. I said, "Tell them don't shoot back here." I didn't know they was killing Brandon.
Well, tonight, Brandon's grandmother, Dorothy Chappell, speaks out for the first time since that 2005 shooting. A federal appeals court ruled those officers should not be held responsible because of qualified immunity. Chappell tells News 5 investigator Joe PAGONAKIS that law needs to be changed.
Well, qualified immunity is a defense for officers here at Cleveland Police Headquarters and officers across the state of Ohio. But the family of Brandon McCloud believes that law, which proponents say protects officers from frivolous lawsuits, is also keeping officers who do wrong from being held accountable.
From day to day, my heart hurt every minute of the day.
Dorothy Chappell has not entered her grandson Brandon McCloud's bedroom since he was shot and killed by two Cleveland police detectives in September of 2005. The room untouched. His alarm clock never reset. Brandon's shoes still in the closet where his body was found after he was shot.
I don't think they had anything good in mind when they went up them steps.
Dorothy was home when police entered her house with a search warrant. Cleveland detectives Philip Habib and John Kranick told investigators McCloud lunged at them with a steak knife, causing them to open fire. But Dorothy believes the officers did little to try and de-escalate the situation before firing the fatal shots.
When they saw him, he was in a closet. That closet didn't even have a door.
4 years later, in 2009, a federal appeals court ruled the detectives acted reasonably and protected the city and the detectives from civil prosecution due to qualified immunity, which is a defense police and other government officials can use in response to civil suits for alleged civil rights violations. The case never went to trial.
All those facts created a situation where it required a trial, not a summary judgment.
McCloud family defense attorney Terry Gilbert believes if officers are to truly be held accountable, qualified immunity must be eliminated, requiring a jury trial in these cases.
And I think that getting rid of it would not deprive the police of the right to defend themselves.
But Cleveland Police Union President Jeff Fulmer disagrees, saying it's a shame in today's society that a police officer gets the blame when dealing with violent juveniles and are open for future lawsuits when in fact it is parenting failures. Meanwhile, Dorothy says she'll continue to fight for change in honor of her grandson.
I have a love that never dies. I will have that love until I die.
And according to a May report from the National Conference of State Legislatures, 4 states, including Colorado, Massachusetts, New Mexico, and Connecticut, have passed laws limiting qualified immunity defenses. I'm News 5 investigator Joe PAGONAKIS.